Hi, my name is Raj Sharma. I'm a partner with Stewart Sharma Harsanyi, Calgary's largest immigration law firm, and today I'm here to talk to you about residency obligations for permanent residents. There's a lot of benefits to being a permanent resident of Canada. For example, you can live, work, study anywhere in this country, and of course, you're entitled to social benefits such as healthcare. And of course, as a permanent resident, you get to apply for citizenship after living in Canada for 3 years out of the last 4. With these benefits comes obligations, and one of the most important obligations for a permanent resident is staying in this country 2 years out of 5. So we'll call this the 730-day rule. And to comply with the 730-day rule, either you have to be living in Canada. Now there's some exceptions. For example, if you're living abroad and you're accompanying your spouse who's a Canadian citizen, then those days living abroad count towards your residency obligation here in Canada. Same thing applies if you're a child, a permanent resident child, and accompanying your Canadian citizen parent outside of Canada. There's also an exception if you are working full-time for a Canadian business or working for the federal or provincial public service abroad. Those days abroad count towards your residency obligation in Canada as well. If you're short of days, don't embellish or exaggerate your time in Canada. Do not lie on any application or to any immigration officer about your time in Canada. As in most things in life, covering up a crime is frequently worse than the crime itself. You may avoid a negative residency determination if an officer finds that your circumstances warrant humanitarian and compassionate consideration. However, if an officer feels that you're in breach of your residency obligation, that officer will issue what's called a Section 44 report, and that's a report concerning inadmissibility. And the specific section that deals with the breach of the residency obligation is Section 28 of the Immigration and Refugee Protection Act. In the event that an officer issues such an order, you can appeal that to the Immigration Appeal Division. You have 30 days to appeal the decision of the officer on a breach of your residency obligation, and the Immigration Appeal Division can also consider all the circumstances of your case, including humanitarian and compassionate consideration. The factors that the Immigration Appeal Division typically looks at include the degree of your non-compliance. It includes the reason for your departure from Canada. It includes the continuing connections you may have in Canada, including to family members. It looks at hardship to those family members if you're unsuccessful in your appeal. And of course, it looks at hardship to you if you are unsuccessful in your appeal and you lose your status in Canada and have to leave Canada. At the conclusion of the hearing, the Immigration Appeal Division can either allow your appeal, allow you to stay in Canada and maintain your status here, or it will dismiss your appeal, in which case you will lose status and you will stop being a permanent resident of Canada. There are limited avenues of recourse if there's a negative determination by the Immigration Appeal Division. You do have the ability to seek judicial review of that decision at the Federal Court of Canada. Given the serious consequences of failing to comply with your residency obligation and the loss of status that it may result in, I would strongly urge you to contact experienced immigration counsel. Thank you for watching this video. Feel free to contact us at Stewart Sharma Harsanyi concerning this or any other immigration issue you may encounter. Thank you.